Good evening. My name is Monica Lowley, and today I will be discussing the research analysis of the Supreme Court case between the Federal Trade Commission and Actavis. The 2013 Federal Trade Commission versus Actavis Supreme Court case involved patent litigation and whether reverse payments from a brand name drug manufacturer to the generic drug manufacturer could be justified. So reverse settlement payments are meant to be settlements to the generic drug manufacturer to delay the entry into this market for a set period of time. So on June 17th, 2022, the Supreme Court determined that reverse payments were not unlawful, but were subject to the scrutiny under the rule of reason. The court ruled that the FTC's case should have been given the opportunity to continue due to the Hatch-Waxman Act and the suspicious characteristics of the settlement and the potentially unjustified competitive consequences, and remanded the case for further proceedings. So here we can see that on February 2nd, 2009, the FTC filed a complaint with the Federal District Court that challenged Solvay Pharmaceuticals for the delayed release of generic and a more affordable option for their brand name drug Androgel. So Androgel was actually the company's top producing drug. It gave the company over $300 million in sales by 2006. When Watson and Paddock Pharmaceuticals received final approval that their Androgel equivalent was ready for the market, Solvay predicted that their sales would decrease exponentially due to Watson's generic drug being significantly more affordable and accessible. So prior to their release, Solvay executives sued the generic companies on interfering with Solvay's Androgel patent. In the end, all three pharmaceutical manufacturing companies later decided to collaborate with Solvay for financial gain in order to avoid competition by accepting payments from Solvay to prevent the lower cost alternatives to be produced. The district court dismissed the complaint from the FTC. The 11th Circuit concluded that this decision was made because the settlement was immune to the antitrust attack if the outcomes of the settlement fall within the scope of the patent. Then the FTC fought to provide evidence that they should have been given the chance to prove its antitrust claim, stating that the reverse settlement agreement will not allow the manufacturers to introduce the generic drug in a timely fashion. The FTC also suggested that Solvay and the manufacturing companies could have settled in other ways rather than the reverse payment method, which in the end hindered patients and threatens to work unjustified anti-competitive harm. After the FTC appealed the district court's decision, the court declined to hold that the reverse payment method was against the law. Now, from the perspective of the Supreme Court, they view that the method of reverse payment settlement, depending on the circumstance, could potentially be unjustified and violate the antitrust laws. They believe that the 11th Circuit should have given the FTC the opportunity to continue their lawsuit. And then similarly to the district court, the Supreme Court also upholds the value of settlements, of disputes, but they believe that this specific case meets the criterion of a similar case from 1999 that was the California Dental Association versus the FTC. In the California Dental case, the Supreme Court unanimously held that abandoning the rule of reason in favor of presumptive rules, also known as the quick look approach, is appropriate if the means would have an anti-competitive effect on the consumers. The reasoning behind this is due to the magnitude related to future litigation expenses, the independence from other services from which it represents payment, and lack of justification. And then in the dissent, Honorable Roberts, along with J.J. Scalia and Thomas, the proper approach should have been to investigate whether the settlement gave Solvay monopoly power above the margins of the patent. Here we can see that Honorable Roberts stated that the court's approach does not include supporting statutes and will discourage future patent litigation settlements. According to the dissent, Solvay paid the pharmaceutical manufacturers in accordance to their patent and gave them money for dropping their legal claims against Solvay. From the justice's perspective, the court's focus on only performing an antitrust analysis of the settlement rather than verifying the validity of the patent and whether the patent holder is abiding by the rights of the patent scope. Overall, he believes that the decision from the majority weakens the protections to innovators by patents and frustrates the public policy in favor of settling. So some of the case implications are that this case involved the lack of generic substitute medications for patients who could potentially rely on this drug to work towards becoming healthier. By eliminating potential competition, patients' lives were impacted due to Watson and Parapatic having to wait until 2015 for generic entry into the market. States promote generic competition through laws so that patients can benefit from more affordable medications. These laws allow for pharmacies to fill the brand name description with the generic alternative for the patient to have more accessibility and opportunity to afford it. So for the conclusion, in the wake of the Supreme Court's decision, the amount of pay-for-delay settlements did decrease the following year in 2014. In my opinion, patents should always be subjected and analyzed for their validity and make sure they do not violate any antitrust laws. There has been a benefit to the Supreme Court ruling showcasing that pay-for-delay settlements have decreased overall, but these settlements still have a grave impact on the affordability of medications for patients. Whether it is androgel in this specific case, or a life-saving chronic medication, restricting the entry of generic competition hinders patients from receiving the medical treatment that should be more available to them. Thank you. Have a great day.